Hello, I'm Paul Peterson. Looking into and figuring out whether you need a will or a revocable living trust, also known as a living trust, can be confusing for seniors. Wills and living trusts serve different purposes and produce different results. On our program today, we will learn what each document does and does not do, and the differences between the two so that you can make an informed decision on which is right for you and your family. Please stay tuned for Aging in LA. Life planning includes making decisions about the end of life. In order to protect your assets and control how your estate is divided, it is important to understand wills and trusts, what probate is, and make these very personal decisions while you still can. Depending on the planning you have done, and when you die, your assets will likely be taken care of in one or more principal ways: probate, community property, probate avoider, and small estate. You can use different routes for different assets opportunities. Today's guest will help us to know the steps to take to sort out a person's estate. Bob Malakote, decedent estate attorney, and Janet Morris, caregiver project director at Zedek Legal Services. Thank you both for joining us. Bob, if I may, excuse me, Janet, let me start with you. It is a difficult thing for families to come for legal services. How do you welcome a family that's come to you for legal advice?
I think the first and most important thing is to try to create an atmosphere of comfort and relaxation. Some people tend to have a fear of making a will, with the idea that if I do this, I've sort of said I'm ready to go and life's over.
Yeah, it's like, whoa. Exactly.
So we try our best to make it a comfortable setting and get rid of the austerity that would sometimes make people feel very uncomfortable. And we find that they communicate much better if they're comfortable.
Exactly. And Janet, as the family caregiver director of legal services for Bet Zedek, it's often the caregivers who come to you for legal advice because they see an approaching problem.
Yes, they do. And they need to know what to do and when to do it. And the earlier the better. So we really advocate for early planning for everybody.
Okay. Well, now, Bob, I got to ask you, what is a probate avoider?
Well, I think you're probably talking about using the idea of a living trust in place of a will. A will, for instance, is a document that doesn't have any life to it until the person who made it dies.
I see.
On a trust, you create it now, and you live with the trust. And you transfer your real property to it, and you transfer other registrable property items. And you literally live with a trust. In other words, it's quite different in the sense that it is alive before you die.
What a wonderful explanation. Thank you. That makes a lot more sense. I'm embroiled in all of this with families. There are many things to accomplish as you approach end-of-life decisions, hopefully with the person still there with all their faculties. But what happens when a person has lost their ability to think clearly or can't take care of themselves? How do you handle that, Janet?
Well, that's a big problem because when a person has lost capacity, they've lost the ability to pre-plan. So they can't make a will, they can't make a living trust, they can't do a power of attorney. And the default is that somebody has to go to court and get a conservatorship in order to make decisions for them. And this is very costly, it's very time-consuming, and we try to avoid conservatorship by doing pre-planning.
Right. Well, it only takes one experience with probate for you to figure out, for the rest of the family, we better take care of this now. And it's not a very expensive process to establish these trusts or to register a will, is it, Bob?
To many people, it would be expensive. But they need to stop and think about whether I buy something like a can of beans at the store, all pre-set up at a real bargain price, or whether I'm going to be able to sit down with somebody and say, here's my circumstances. They're different from this fellow and this lady over here and so forth. To have it tailor-made to your needs and to have someone that's going to prompt you into thinking about things that you should be considering is extremely important.
Yeah, people, I think, don't understand what the aggregate worth is of the things they own and possess. I mean, beginning with their homes, goodness, with this real estate prices, it's really significant. Is there a certain threshold where really you must think about this?
Yes, this is part of a planning process. We call it estate planning. With a little guidance, your family and ultimately your heirs can be a lot further ahead in terms of what you leave them if you take the time to plan now. Now, there'll be some people with a very modest income and a modest assets who may think that they don't have anything really to pass on. Well, nowadays, as you just mentioned a few minutes ago about real estate, you've got many people living in a little 5-room house that is worth $1 million.
Yes, all over the Los Angeles area. That's the truth. Now, there are some terms, Janet, that really, I think are troubling to people because they don't quite understand what they're extending to another person. The two things, the power of attorney on financial affairs and the power for making medical decisions. Can you explain a bit about that? Because often the medical decisions can be really significant.
Sure, I'd love to. And these two planning devices are things that you want to do to give your loved ones authority while you're still alive, but incapacitated. And the wills mostly the wills and the living trust are for after your death.
Right.
So while you're alive, there's a long period of time when people, because they're staying alive a lot longer these days, need to transfer authority to someone so that their loved ones can make decisions for them while they're alive.
Right.
So there's two different parts. Power of attorney for health care transfers medical decision-making power. So the power to talk to your doctor, get health records, make decisions about end-of-life care, about surgeries and things. And then there's the power of attorney for finances, which transfers authority to someone to make financial decisions, to buy and sell real property, rent your property, even sign your tax returns. Because if you're incapacitated in the hospital, who's going to do that for you?
Well, that's of course the issue. And I think people must understand, especially people of a certain age, that it is often not a good idea to have a government bureaucrat making decisions for your family. Now, a living trust, Bob, that helps establish the division and the sort of care you have provided for, right? And does that include like your final expenses, burial expenses, etc.?
Yeah, the trustee and what will become the successor trustee after you as the creator of the trust passes on is able to do all kinds of things. The scope is quite broad.
Really?
Buy, sell property, as Janet just mentioned, take care of making decisions with regard to assets and when to liquidate or what requires liquidation, so on and so forth. The trustee can do things fairly rapidly after death. This is probably one of the distinct advantages over a probate. If an estate goes into probate, you're probably going to look at a year or very close to that and maybe more.
Wow, a year. And in the volatile times we live in, a lot can change in a year.
Yes.
Wow. I didn't realize that. Now, are there, what if you want to make provisions for your favorite charity or your church? Can this be included in
It can be in a trust or it can be in a will, either way.
Either one.
Yeah.
Because I know I often see those who are left behind begin to squabble over the largesse of the decedent to what they know to be their favorite church or house of worship. Do you see that, Janet?
Sometimes, and that's why it's important for people to plan so that everybody knows what they wanted. Because if they don't plan, then maybe the heirs don't either squabble or don't know or appreciate how much the decedent wanted some money to go to their favorite charity or church or whatever. So.
Well, there's almost something superstitious, though, about discussing end-of-life issues, because the end of life, thanks to medical technology, can really be extended these days. Often you outlive your resources, or you find yourself in a medical condition that is going to be costly and may require some real sophistication in the decision-making process. Let's say you're 95, exactly how much medical care do you want if there's a crisis? Can people, as they create these living trusts or wills, establish like do not resuscitate orders?
Well, the purpose of an advance directive or a power of attorney for health care is exactly that. To appoint someone to make decisions, first of all, and second of all, to give your desires and an explanation of what type of care you want at the end of life.
Right. See, to me, that's the most important, because this is not dinner table conversation ordinarily. And I know in my experience, we're often mystified when someone says, well, where do you want to be buried? You know, what are your wishes? Why
Yeah, so it's
is
a
that?
perfect opportunity to write down, you know, if I should be in a coma, I do not want life-sustaining measures provided for me. And if you say that specifically in the document, then the person who is the one making the decisions at that time knows that they're just following your desires. They're not substituting their own decision for yours.
Right. And
So it takes a lot of guilt and relieves people from a burden that they otherwise might have.
right, and I think that's very important. Anytime you face this issue within the family, frankly, I've seen families blown apart by things like this. When you are engaged in estate planning, Bob, do you encourage the beneficiaries of the trust to come in and participate in the process, or is this an individual choice?
Actually, I choose the latter.
Really?
I feel this is a very private document.
Wow.
Also, the fact that you may have a change of circumstances in the years that follow the creation of your trust. And if you've advertised what your trust says, your beneficiaries, it's very awkward to try to make a change.
Wow.
So I recommend that the privacy of your trust should be maintained. Not everybody agrees with me, but this happens to be the viewpoint that I subscribe to.
But this is based on your experience. You've been doing this a long time.
Yeah, over 50 years.
Well, and those of us who appreciate the wisdom of our elders can understand 50 years means something. You've seen an awful lot. You once worked on the probate side of this, where people suddenly, their estates were flung into the court system, and you had to represent the interests of the person who's passed on.
That's correct. You try to present the will. Hopefully it's a well-drawn will. The court then follows the directions unless there's a contest, and anybody can start a contest.
Oh.
We use a provision in most of our wills which says, in essence, if you start fighting over this thing, you're not going to get anything.
Yeah, I've heard of that before.
There's a no contest clause.
No contest clause. But some people go ahead anyway, because people sometimes have accumulated quite substantial estates.
Yeah.
Wow. Does that make it worse?
Well, yes. Obviously, you know, there's no fighting if there's no money. That's a given, right, Bob?
I have to agree with you.
We see that all the time. But, you know, the interesting thing is you asked Bob about, you know, should these be private and put away in the safe deposit box? And I have to agree that a will probably should, but an advance directive for health care shouldn't. People want to put that in a safe deposit box, and we say no, because who's going to know where the key is if you're incapacitated?
On that note, it's time for a short break. When we come back, we will continue our discussion on seniors making important decisions on how to control the division of your estate among your survivors. We'll be right back.
The Los Angeles Department of Water and Power wants to give you up to 7 free shade trees just for completing a workshop, either online or in your neighborhood. The Trees for a Green LA program offers LADWP residents over 40 different varieties of free shade trees. Trees benefit the environment, save energy, and add beauty. Get your trees by participating in an online workshop by logging on to ladwp.com/trees or call 1-800-GREEN-LA.
As kids, it's really important that we learn the proper way to cross a street. First, you have to stop at the curve, then look both ways to make sure there are no cars. If you see one, wait for it to pass, and when it's clear, you can cross. As kids, sometimes you have to set an example. Look both ways before you cross. Cars can't see you.
Welcome back to Aging in LA. Our topic today, understanding wills, trusts, and probate. Our guests are Bob Malakote, decedent estate attorney, and Janet Morris, caregiver project director, Beth Zedek Legal Services. Thank you again for joining us. Now, Bob, the legislature has gotten involved here for people when there are issues about who owns the property. You were mentioning joint tenancy and community property. How does that work for people who have a smaller estate so that the title is clear?
It may be a very convenient way for them to go. We have joint tenancy on one hand, which says, in essence, whoever lives longest wins the battle and gets everything.
Right. Well, it says it should be.
Now, community property is strictly related to husband and wife.
I see.
And this is an item of law that goes back a number of years, but it's only found in the western United States.
Really?
Yeah. The common law is more common in the eastern part of the country.
I see.
But without getting too far away from this, the benefits of community property tax-wise can be quite significant. So the legislature here several years ago created a new kind of deed which actually made it community property with the right of survivorship.
I
so
see.
it combined the two concepts in a very good way. And if you had a small estate and you didn't want to get bothered with probate, and husband and wife are trying to figure out how to handle this, a deed like that to their home may be the perfect answer.
Well, do you have to go to a title company and modify the deed, or is that something your attorney
you
does?
probably could get it at most stationery stores.
Really? Lawyers aren't going to want to hear that.
You really want to stop and think about what you're doing, though, because when you take a particular concept like I've just mentioned,
Yes.
and you just, like a big blanket, try to cover everything, you're very likely to make some mistakes.
I see.
Your needs, my needs, Janet's needs may be quite different. And you need some guidance to accomplish what you really want to accomplish.
Well, that makes such perfect sense. But, so, Janet, why don't we all do this as a matter of course? I mean, maybe somebody's going to have to pass a law that, you hit 40, you start taking care of this stuff. What
I think
makes us?
every adult should think about, what's going to happen. God forbid something happens to them. Everybody over the age of 18. Well, that's, pie in the sky. But at least people who are in their 40s, 50s, and 60s and on should really consider doing the planning documents.
Yeah, well, especially if there are children. I mean, I've seen some of these documents where the children go if, God forbid, mom and dad are, have a gruesome traffic accident. What happens then?
Right. That's why a simple will, and you can get it in a stationery store, but be careful because every state has their own documents and their own laws concerning powers of attorney, advance directives, wills, trusts. So it has to be California-based.
Okay.
Because if you go to a big box stationery store, you're likely to get a non-California form.
Right.
A very small stationery store that has legal forms, you might be able to get the right forms.
I
But
got you.
certainly calling an attorney would be a good thing.
Well, we call the show Aging in LA, so we're going to focus exactly on that. Now, a question people may be asking themselves, what is the difference between a revocable trust and an irrevocable trust? How does that work in real life?
Okay, that's a very excellent question, one that everyone should understand.
Okay.
The concept of a revocable trust is based upon the idea it can be revoked by the trustors, the ones who created it, anytime. Tomorrow I don't want the trust anymore, and you can revoke it.
I see.
Now, when you make an irrevocable trust, it is just that. You aren't going to change your mind and cut out the trust. These are often used in charitable remainder trusts, where people are promised so much a month income if you'll just donate your property to ABC charity.
Right. We see that in some nursing facilities now, where you pledge a certain amount of money and your care is guaranteed.
Well, this is a little bit different. I'm talking now about you're living in your home, and under an agreement you make with the charity that you choose, you can reside in the home as long as you're able, and they will promise to give you so much a month for the rest of your life. Right. The answer there is whether or not the value of the dollar is going to be worth anything down the road.
Exactly.
And I happen to be one who follows economics quite closely. It's a major interest of mine, and I'm scared to death about the value of the dollar. And I think right now, taking an agreement like that should be given some very careful thought as to whether or not it's really a secure position to be in.
I see. Well, that leads me to think of people who have gotten themselves involved with reverse mortgages or things like that, some of these funny mortgages that have caused so much grief. Does that occur as well, Janet? Do people say, I've got to get out of this situation?
Yeah, and I think the idea about doing a revocable trust and documents that I was talking about are revocable. It's very important. But the biggest problem we're having in Los Angeles particularly is we have people with equity in their homes.
Yes.
And they're sitting ducks for people to take advantage of them, especially
yes.
in their older years. And they do use the kinds of documents that I'm talking about, such as powers of attorney, to get somebody to sign over power, and then they mortgage their house and foreclose on it, and that's it, they're gone.
Yeah.
So you have to be very careful who you choose as the trustee, as the successor trustee of your trust, or as the power of attorney, the agent of your power of attorney, so that if you really trust that person, even though it can be revoked later on, you need to find somebody that you really trust that will manage your property for your benefit.
Yeah, this is such a complicated topic, and every person is an individual. But Janet, you are holding in your lap a handy-dandy guide that I want to reference, because I think most of this falls heavily, let's say the water's under the bridge, on those who are left to care for this senior person. So can you explain the book here?
Well, this Caregiver Companion I wrote with my co-author Kim Williams from Betzetic Legal Services, and we basically talked about all the things that elder law attorneys and estate planning attorneys do for people, for care recipients and caregivers. So we talk about powers of attorney for healthcare and finances, wills and trusts, being a good caregiver, where to get resources in Los Angeles and California for caregivers, respite care and things like that. So it's a really great guide. We have it on our website at www.betzetic.org. I think it's on the screen.
Okay, yeah, we'll have it up on the screen, because Betzetic may be a bit confusing.
It's a bit confusing. It means House of Justice in Hebrew, and we've been around for over 30 years. I've been an attorney there for 23 years.
Wow.
So I really wanted to write this book as a companion. We have a nursing home guide and an assisted living guide, and this book is for caregivers, and it really talks about everything you need to know to be a good caregiver.
That's wonderful. Bob, I have been trumpeting the skills and expertise of the Department of Aging right here in Los Angeles, and often they are underutilized. It's almost as if they've got blinkers on. I'm never going to get old. I'm never going to get sick. What do you suggest to people for either approaching you? Do they need a specific goal, or can they come in and just talk to you?
Well, certainly we have to start every planning approach with just talk to you type of situation.
Right.
That's where an attorney has to be one who listens.
Right.
And he will dig into different family relationships, maybe somebody in the family that needs special care.
Right.
All kinds of different things that may be unique to this particular testator. And we shouldn't go beyond this without realizing that many people overlook the fact that when the first spouse passes on, the survivor is tremendously vulnerable.
Oh, yes.
Lonely, willing to do almost anything for a little affection and a little attention.
Yes.
And we've seen this many times, that the people who watch for this situation literally leap on it, and some nasty things have been done.
Well, with the information base that's around these days, folks know when you turn 80 or 90 and they know what you own. And I wish we could have more time for this, but time's up. So thanks so much to our guests, Bob Mallicote, decedent estate attorney, and Janet Morris,